Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss the U.S. Supreme Court's June 23, 2025 ruling in the case captioned Department of Homeland Security versus DVD on an application to stay a temporary restraining order, TRO, issued by Judge Brian Murphy of the U.S. District Court of Massachusetts. As a recap, this case was discussed in episodes 15, 19, and 33. This is the case involving one individual who illegally entered the United States from Guatemala who was deported to Mexico and only given notice of his removal to a third country, Mexico, after he had been put on a bus headed to Mexico. The case also involves several individuals from various countries who had entered the United States illegally but were moved to Djibouti, South Sudan, where none of them are from, without first having the opportunity to challenge the removals. The court found that these individuals were removed after having been deprived of their procedural due process rights under the Fifth Amendment of the U.S. Constitution to first be provided with adequate advance written notice and adequate time to pursue legal challenges prior to their removal. On April 18, 2025, Judge Murphy entered an order stating in part, quote, prior to removing any alien to a third country, i.e. any country not explicitly provided for on the alien's order of removal, defendants must 1. Provide written notice to the alien and the alien's immigration counsel, if any, of the country to which the alien may be removed in a language the alien can understand. 2. Provide meaningful opportunity for the alien to raise a fear of return for eligibility for CAT protections. 3. Move to reopen the proceedings if the alien demonstrates reasonable fear. And 4. If the alien is not found to have demonstrated reasonable fear, to provide meaningful opportunity and a minimum of 15 days for the alien to seek to reopen immigration proceedings to challenge the potential third country removal. That TRO was meant to be in place during the pendency of the litigation in this matter. The Trump administration appealed the TRO to the U.S. First Circuit Court of Appeals, who upheld the TRO and denied their request. Yesterday, on June 23, 2025, the U.S. Supreme Court granted a stay on the TRO while the litigation and substantive issues of the case are litigated in the First Circuit Court of Appeals. This means that the Trump administration may resume third country removals with minimal notice to persons removed at least during the pendency of that litigation. The brief U.S. Supreme Court ruling, which is only a paragraph, which does not list the author's name, states, quote, the application for stay presented to Justice Jackson and by her referred to the court is granted. The April 18, 2025 preliminary injunction of the United States District Court for the District of Massachusetts is stayed pending the disposition of the appeal in the United States Court of Appeals for the First Circuit and disposition of a petition for a writ of certiorari, if such writ is timely sought. Should certiorari be denied, this stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of the court. In layperson speak, this means that Judge Murphy's TRO is lifted while until litigation of the substantive case is completed in the First Circuit and after a potential appeal to the U.S. Supreme Court is ruled on, meaning whether the Supreme Court decides to hear any potential appeal from the First Circuit. If the Supreme Court denies certiorari, meaning they refuse to hear the case and the parties are stuck with the final First Circuit ruling, the stay on Judge Murphy's TRO will be lifted. If the Supreme Court grants certiorari and agrees to hear a potential appeal from the First Circuit, the Supreme Court's stay on Judge Murphy's TRO shall be lifted at the time the Supreme Court issues a final ruling on that potential appeal. This means that the Trump administration, in the meantime, can resume removing individuals to third countries with minimal notice, despite concerns that this practice may violate due process rights under the U.S. Constitution's Fifth Amendment. I'm going to quote some of the dissenting opinion in this matter that was drafted by Justice Sotomayor, where she was joined by Justices Kagan and Jackson. Quote, in matters of life and death, it is best to proceed with caution. In this case, the government took the opposite approach. It wrongfully deported one plaintiff to Guatemala, even though an immigration judge found he was likely to face torture there. Then, in clear violation of a court order, it deported 6 more to South Sudan, a nation the State Department considers too unsafe for all but its most critical personnel. An attentive district court's timely intervention only narrowly prevented a third set of unlawful removals to Libya. Rather than allowing our lower court colleagues to manage this high-stakes litigation with the care and attention it plainly requires, this court now intervenes to grant the government's emergency relief from an order it has repeatedly defied. I cannot join so gross an abuse of the court's equitable discretion. Third country removals are burdensome for the affected non-citizens, so Congress has sharply limited their use. They are permissible only after the government tries each and every alternative noted in the statute and determines they are all impracticable, inadvisable, or impossible. Non-citizens facing removal of any sort are entitled, under international and domestic law, to raise a claim under the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. Article 3 of the Convention prohibits returning any person, quote, to another state where there are substantial grounds for believing that he would be in danger of being subjected to torture. The United States is a party to the Convention, and in 1998, Congress passed the Foreign Affairs Reform and Restructuring Act to implement its commands. The act provides that, quote, it shall be the policy of the United States not to expel, extradite, or otherwise affect the involuntary return of any person to a country in which there are substantial grounds for believing the person would be in danger of being subjected to torture, regardless of whether the person is physically present in the United States. 8 United States Code, Section 1231. On February 18, 2025, the Department of Homeland Security, DHS, issued an internal guidance document directing officers to review for removal of all cases on the non-detained docket and determine the viability of removal to a third country. Just as DHS circulated this new policy, a Guatemalan man known in this litigation as OCG appeared before an immigration judge to seek relief from his impending removal to Guatemala. OCG explained that he had previously been forced to flee Guatemala after facing torture and persecution there for his identity as a gay man. He fled initially to Mexico, he said, but had not found safety there either. A group of men raped him and locked him in a room until his sister paid them a ransom. OCG accordingly asked the judge whether he, quote, could be deported to a country other than Mexico or Guatemala. The immigration judge granted withholding of removal to Guatemala, the only country designated in the order of removal. Because the government had not sought to remove OCG to Mexico, the immigration judge did not address his request for protection against removal there. 2 days later, Immigration and Customs Enforcement escorted OCG out of his cell and put him on a bus to Mexico. On the way, they provided him with, quote, oral notice that he would be removed to Mexico. DHS did not issue a new order of removal designating Mexico, did not reopen the prior proceedings that did not provide either OCG or his lawyer with advance notice. Mexican authorities promptly deported OCG back to Guatemala, where he went into hiding. Along with 3 non-citizens who feared that they too would imminently be whisked off to a third country without notice, OCG filed this putative class action under the Administrative Procedure Act, APA, against DHS Secretary Nome and Attorney General Bondi. Plaintiffs allege that the government's apparent policy of removing non-citizens to a third country without notice or the opportunity to file a claim under the convention violated the immigration laws, the regulations implementing the convention, and the Fifth Amendment's Due Process Clause. DHS arrested 4 putative class members covered by the TRO. As the government admits, DHS typically arrests people to remove them. Indeed, DHS promptly transferred the 4 arrested class members to Guantanamo Bay. Notwithstanding the TRO's express prohibition on third country removals without notice or process on March 31st, the government placed all 4 class members held in Guantanamo Bay on a Department of Defense flight to El Salvador. On April 18th, the district court granted the plaintiff's motion for class certification and for a preliminary injunction. holding that the plaintiffs had shown the government's process for conducting third-party removals likely violated the Due Process Clause. The injunction requires the government to provide non-citizens with written notice in advance of third country removal, along with a meaningful opportunity to raise a claim under the convention. On May 7th, plaintiffs' counsel received news reports, quote, announcing the imminent removal of Laotian, Vietnamese, and Philippine class members to Libya, again, without notice or an opportunity to object. Plaintiffs thus sought emergency relief from the district court. That same day, the court issued an order clarifying its preliminary injunction so as to leave no doubt that the allegedly imminent removals would clearly violate the preliminary injunction. That order narrowly averted the deportations. Less than 2 weeks later, plaintiffs' counsel received reports of plans for yet more unannounced third country removals, this time to South Sudan. At an emergency hearing, government lawyers confirmed that several class members were indeed en route to South Sudan after having received less than 24 hours notice of their impending deportations. By the time of the hearing, quote, DHS believed that the plane could not be turned around, but was unwilling to share its location. More details emerged the next day. At approximately 5:45 on the evening of May 19th, DHS provided 6 inmates of an immigration detention facility with a document indicating they would be removed to South Sudan. At 9:35 a.m. the next morning, DHS removed them from their cells and put them on a plane. Short of the non-citizens yelling at any of the jailers that they were afraid to go to South Sudan, DHS did not offer the non-citizens an opportunity to assert a claim under the convention. The district court found that DHS had unquestionably violated its order. Nonetheless, at the government's request, the court permitted the government to provide the requisite process in South Sudan and did not order the class members returned to the United States. Meanwhile, discovery proceeded on the status of OCG, the Guatemalan man with whom this case began. The government had previously attested that before OCG's removal, an officer had asked him whether he was afraid of returning to Mexico, and OCG had responded that he was not. On the eve of that officer's deposition, however, the government submitted an errata sheet admitting the information had been false. Because OCG had been removed to Mexico without notice or an opportunity to file a claim under the convention, the district court ordered the government to facilitate his return. The government eventually agreed to comply with that order. The government has appealed the merits of the preliminary injunction to the First Circuit, where briefing is ongoing. Pending that appeal, it seeks permission to continue its practice of conducting third country removals without notice. Both the district court and the First Circuit denied that request. This court will grant a stay pending appeal only under extraordinary circumstances, especially where 2 lower courts have already denied such relief. Ordinarily, the court considers the likelihood of irreparable harm to the applicant absent emergency intervention, the applicant's likelihood of success on the merits of an appeal to this court, and the equities. Begin with the basic proposition that all orders and judgments of courts must be complied with promptly. This court often reiterates that, quote, a stay is not a matter of right, but an exercise of judicial discretion. For centuries, courts have closed the doors of equity to those tainted with inequitableness or bad faith relative to the matter in which they seek relief. See the clean hands doctrine. That principle, rooted in historical concept of the court of equity as a vehicle for affirmatively enforcing the requirements of conscience and good faith, ensures that the court does not become abettors of inequity. Here, in violation of an unambiguous TRO, the government flew 4 non-citizens to Guantanamo Bay and from there deported them to El Salvador. Then, in violation of the very preliminary injunction from which it now seeks relief, the government removed 6 class members to South Sudan with less than 16 hours notice and no opportunity to be heard. The government thus openly flouted 2 court orders, including the one from which it now seeks relief. Even if the orders in question had been mistaken, the government had a duty to obey them until they were reversed by orderly and proper proceedings. That principle is a bedrock of the rule of law. The government's misconduct threatens it to its core. So too does this court's decision to grant the government equitable relief. This is not the first time the court closes its eyes to noncompliance, nor I fear will it be the last. See Trump versus JGG. Yet each time this court rewards noncompliance with discretionary relief, it further erodes respect for the courts and for the rule of law. Without a showing that a stay is necessary to avoid irreparable harm, however, this court's midstream intervention is inexcusable. Besides the facially absurd contention that the executive is irreparably harmed anytime a court orders it to temporarily refrain from doing something it would like to do, the government has identified no irreparable harm from the challenged preliminary injunction. The government has made clear, in word and deed, it feels itself unconstrained by law, free to deport anyone, anywhere, without notice or an opportunity to be heard. The episodes of noncompliance in this very case illustrate the risks. 13 non-citizens narrowly escaped being the target of extraordinary violence in Libya. OCG spent months in hiding in Guatemala. Others faced release in South Sudan, which the State Department says is in the midst of an armed conflict between ethnic groups. Only the district court's careful attention to the case prevented worse outcomes. Yet today, the court obstructs those proceedings, exposing thousands to the risk of torture or death. Given its conduct in these proceedings, the government's posture resembles that of the arsonist who calls 911 to report firefighters for violating a local noise ordinance. In any event, the government has not established a likelihood of success on any of its arguments. The Due Process Clause represents, quote, the principle that ours is a government of laws, not of men, and that we submit ourselves to the rulers only if under rules. By rewarding lawlessness, the court once again undermines that foundational principle. Apparently, the court finds the idea that thousands will suffer violence in far-flung locales more palatable than the remote possibility that a district court exceeded its remedial powers when it ordered the government to provide notice and process to which the plaintiffs are constitutionally and statutorily entitled. That use of discretion is incomprehensible and it is inexcusable. Respectfully but regretfully, I dissent. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.